This is Colin O'Keefe here for LXBN TV in a case coming out of the Fifth Circuit involving Halliburton. The court ruled that outing a whistleblower constitutes as what's called adverse action under Sarbanes-Oxley. Joining me now to explain exactly what happened and also what this could mean for employers is attorney Steve Pearlman. He is our resident whistleblower expert and he's with Proskauer in Chicago and author on the firm's blog, Proskauer Whistleblower Defense. Steve, first off, can you walk us through exactly what happened here? What's the backstory on this ruling and why they ruled the way that they did?
Sure, Colin. This really is a case of major significance. I'd go so far as to say that this is mandatory reading for in-house employment counsel and for compliance professionals. What happened here is that an employee of the company lodged a complaint through internal compliance channels and also complained to the SEC. The SEC in turn contacted the company and in part of its spiel to the company told the company that it needed to preserve documents. And the company made a conscientious good faith effort from my reading of the opinion to do so. And in the process of doing so, however, it identified who the whistleblower was. So the whistleblower in turn alleged that he faced ostracism and unfavorable treatment because his identity was outed to his colleagues and to superiors. And so the employee proceeded to file a claim under Section 806, the whistleblower protection provision in Sarbanes-Oxley. And this was a case that was the first of its kind. It's a landmark decision. It has a long wrangled procedural history. It went from OSHA to an ALJ to the ARB, back to an ALJ, back to the ARB, and then to the Fifth Circuit Court of Appeals. The Fifth Circuit Court of Appeals was confronted with the question of whether or not this outing, so to speak, of the whistleblower constituted an adverse employment action and whether or not there was a contributing factor question that was met. And as you can see from our blog post, the Fifth Circuit ruled in favor of the whistleblower.
I see. And then going to that blog post that you mentioned right there, you mentioned in your piece that this raises a number of risks for employers. So let's jump to that, kind of the lessons from this case. What are the risks that it raises? What are the lessons that employers should take away from this ruling coming out of the Fifth Circuit?
This ruling really does raise some very serious risks for employers, particularly when employers are trying to create a rock-solid litigation hold in a conscientious, good faith manner. In order to have an effective litigation hold, the employer in this case apparently wanted to make sure that any documents that concerned the plaintiff and the plaintiff's activities here were preserved. But in doing so, the employer, of course, identified who the employee was so that could be carried out and accomplished. But the employer stance would be no good deed goes unpunished in this sort of situation. Trying to act conscientiously resulted in the outing of the employee. Now the employer says, hey, look, we had no nefarious motive. We had no retaliatory motive. We weren't trying to do anything to hurt anybody. Quite the contrary, we had good motives. We were trying to preserve documents. And in a surprising move, the Fifth Circuit said, well, that's not terribly important to us. The question of retaliatory motive is not dispositive of this issue. And in giving that pronouncement, relied on a decision that's outside of the Sarbanes-Oxley whistleblower context. So you have two key points there. Number one is that no good deed went unpunished here. Employers need to be extremely careful when crafting a litigation hold not to out an anonymous whistleblower. And number two, when we're litigating these cases, query whether other courts will defer to this court's determination that motive is not a dispositive consideration in a whistleblower action. That's very concerning because retaliation, by definition, requires a motive to get back at somebody. But the Fifth Circuit isn't going that far.
Yeah, it's going to be fascinating to watch, like you mentioned, to see if other courts, abide by this type of thing, to see if they take similar action. Because, like you mentioned, it is, no good deed goes unpunished, and really, companies now just can't be careful enough when it comes to these types of things. Once again, that was attorney Steve Pearlman of Proskauer. For his full analysis of this case, be sure to check out his blog post. It is at whistleblowerdefense.com. It's whistleblower-defense.com. Thank you for joining me today, Steve.
And thank you, Colin.